Welcome to The Explainer. Today we're diving into a single legal case that completely changed how the law thinks about psychological trauma and, who really counts as a victim.
So let's kick things off with a pretty challenging question, one that gets right to the heart of this landmark 1983 case, McLoughlin versus O'Brien. It really forces you to think, where does the impact of an accident actually end?
Our story begins, and sadly, like a lot of these major legal cases, it starts with a truly devastating event that just shattered a family's world in a single moment.
Okay, so the core facts are tragic, and they're painfully simple. There's a horrific crash, and for the McLoughlin family, the consequences are just unthinkable. The husband and two of the kids are badly injured, and just heartbreakingly, their youngest daughter is killed.
But here's the thing. The crucial part of this case, the part that really changed everything, wasn't the accident itself. It was what happened about 2 hours later.
See, Mrs. McLoughlin wasn't there at the crash site. She was at home, a couple of miles away, with absolutely no idea what had just happened to her family. It was a neighbor who had to bring her the terrible news and then rush her to the hospital.
And what she walked into at that hospital? Well, it wasn't a cleaned-up, sanitized scene. She saw the immediate, raw, completely unfiltered aftermath of this tragedy. Her family, still covered in the oil and mud from the wreckage. This direct sensory experience, that is absolutely key here.
That experience was so profound that it caused Mrs. McLoughlin to suffer from severe shock, clinical depression, a fundamental change in her personality. Now, the legal term for this back then was nervous shock. And we need to be clear, this isn't just feeling sad. We're talking about a genuine, diagnosable psychiatric illness brought on by a horrifying event.
So this deeply personal tragedy created a massive puzzle for the courts, one that the old, rigid rules of the time just had no answer for.
It all boiled down to this one crucial question. Could the person who caused the accident also be legally responsible for the psychiatric injury to a loved one who wasn't even there? I mean, did the law's protection really stretch that far?
Under the existing rules, the answer was a hard no. The law was incredibly narrow, like a tiny little box. You had to be physically present, right there in the area of impact, seeing it with your own eyes. Mrs. McLoughlin's case was trying to smash that box wide open. This case was so important that it went all the way to the top, to the House of Lords, which was the UK's highest court back then, and the judgment they handed down was a total game changer.
In a landmark decision, they actually sided with Mrs. McLoughlin. They recognized that the severe shock she suffered was a direct and, importantly, foreseeable consequence of the driver's negligence. It didn't matter that she was separated by time and distance.
And Lord Wilberforce, one of the judges, made this incredibly powerful point. He basically said that the law can't be a fossil, frozen in time. It has to evolve to reflect our modern understanding of psychological harm and what society thinks is fair and reasonable.
But they didn't just want to make a one-off decision. They couldn't just open the floodgates, right? So they created a new framework, a new rule book for judges to use in cases like this going forward.
And this is what they came up with, a 3-part proximity test. It's like a checklist. First, is there a close tie of love and affection? Like a parent or a spouse. Second, was the person close to the accident in time and space? And, this is the big one, they decided that witnessing the immediate aftermath absolutely counts. And third, was the shock caused by what you saw or heard yourself, not by somebody telling you about it over the phone?
So the legacy here is huge. This case blew up the old idea of proximity. It officially recognized psychiatric harm as a real, foreseeable injury. And it created this legal pathway for what we now call secondary victims, people who were hurt by what they witnessed, even if they weren't in physical danger themselves. It was a brilliant balancing act, giving victims justice while also setting clear limits to stop an endless flood of claims.
The McLoughlin case provided a brave, compassionate answer for its time. But it leaves us with this much bigger question that courts are still grappling with today. In our crazy, interconnected world, just how far should responsibility for emotional and psychological harm really extend?